Hi, my name is Anki Kwan. I'm a California lawyer and my law firm Vanguardium Legal represents blockchain and technology startups. In this episode, I wanted to go over 3 exemptions that you can use to sell to non-accredited investors. As you may know, if you are offering or selling a security, no matter what form it is in, whether it's a token or something else, you either have to register that offering or find an exemption to registration. A lot of companies only sell their securities to accredited investors because they think it's too hard to sell their securities to unaccredited investors. Today, I want to give you a few options that you can use to offer and sell your securities to non-accredited investors, because I know that in the ICO space and in the token sales space, it's important to build a community, and one way to do this is by selling to both accredited and non-accredited investors. So here are a few ways that you can do that. Regulation A or A+ allows you to sell up to $50 million of securities to both accredited and unaccredited investors. Under Regulation A+, you do have to do a filing with the SEC, and your disclosure requirements are quite high, but it allows you to raise up to $50 million. Unfortunately, your disclosures are almost as extensive as they would be under a registered offering, so keep that in mind if you are thinking about doing Regulation A+ offering. The next exemption you can use is Regulation Crowdfunding or Regulation CF. Under Regulation Crowdfunding, you can offer up to $1.07 million of securities to both accredited and non-accredited investors. You do have disclosure requirements under Regulation Crowdfunding, and you can only offer your securities through something called a funding portal. But your disclosure requirements aren't as high as they would be under Regulation A+, but $1 million is also far less than what you would raise under Regulation A+. Next, we have Regulation D. Regulation D is most popular for Rule 506 because this allows you to raise an unlimited amount of money. Specifically, Rule 506B allows you to raise an unlimited amount of money from accredited investors, and you can also raise money from up to 35 non-accredited investors. The catch is, if you try to raise money from even one non-accredited investor under Rule 506B, you have to disclose a lot of information to your investors, and the level of disclosures is almost as high as it would be in a registered offering. So selling to even one non-accredited investor under Rule 506B can get really expensive, and your investors also have to be sophisticated. Compare that with Rule 504 under Regulation D. Rule 504 allows you to raise up to $5 million from accredited and non-accredited investors. But unlike under Rule 506B, you don't have any mandatory disclosure requirements, and your investors also don't have to be sophisticated. That means that your friends and family who don't otherwise meet the sophistication requirements can invest in your offering if you're doing a 504 offering. And not having to have mandatory disclosures means that you can spend a lot less money doing a 504 offering than you would doing these other types of offerings. But as you can see, your limits on how much you can offer varies depending on the type of exemption that you can use. And this is only a brief overview. There are other details about these exemptions that you do need to know when deciding which exemption to use. I hope you found this video helpful. If you did, please share with someone who you think may benefit from watching. And have a great day. Bye.